Hey everyone, thank you for coming. My name is Eric Beal, and I'm the president of Nevada's Federal Society Student Chapter. We have a very special guest speaker today to discuss the issue of antitrust populism and the rule of law. Ashley Baker is the director of public policy at the Committee for Justice. Her focus areas include the Supreme Court, technology and regulatory policy, and judicial nominations. Her writing has appeared in Fox News, USA Today, and the Boston Globe, The Hill, Real Clear Politics, The American Spectator, and elsewhere. She is also the founder of the recently formed Alliance on Antitrust Coalition. Ashley is an active member of the Federalist Society, where she serves as a member of the Regulatory Transparency Project's Antitrust and Consumer Protection and Cyber and Privacy Working Groups. As a member of the Republican National Lawyers Association, she has served as a member on the Supreme Court and the Federal Judiciary. Ashley also serves as the official observer on the Uniform Law Commission's drafting committee on the collection and use of personally identifiable data. As an expert on the judicial nomination process, Ashley worked closely on the efforts to confirm Justices Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett, and Judge Naomi Rao. Most of Ashley's work is at the intersection of courts, regulation, and technology. Ashley engages in policy analysis and outreach on legislation and regulations related to these issues by writing op-eds, letters to Congress for committee hearings, and regulatory comments to a broad array of executive agencies, including the FTC, NTIA, FCC, DOL, SEC, and the DOJ Antitrust Division. She also conducts CFJ's external affairs and outreach efforts. Please welcome Ms. Baker.
Thank you. Thanks for having me, Eric. There's never been really a more exciting time, I think, to work on antitrust law than it is right now. It's a quite in-demand topic, it seems, very suddenly. But it's an area of law that's been pretty well settled since around 1977 or so, but we've seen a lot of action in both Congress and some in the courts and on the state level as well. So now's a really good time, I think, to revisit some of the bigger questions about antitrust and what is the role of antitrust in the economy and in our society. So not only does this debate present some interesting legal and economic questions, at the same time, today's antitrust debate underscores some interesting rifts and tensions within both political parties, serving as somewhat of a microcosm of broader political dynamics. Some of the questions that are framed around big tech are really much broader questions about the role of government versus private power, and particularly in how and to what extent they should shape our markets and the US economy. So today I'd like to discuss some recent antitrust proposals and the history of the law and how we got to where we are today, as well as the considerations you guys probably hear more about concerning big tech. But first, I'd like to address the theme that's really kind of embodied in the title of this event, which is antitrust populism and the rule of law, or as a question, is the way in which we interpret and enforce antitrust law today at odds with the rule of law? So recently, there's been a lot of arguments that the antitrust law as it currently stands is inadequate because companies are too big, or because of concerns over free speech or privacy, or income, or just a whole host of different issues that are completely detached from competition law. And I'd like to address each of these in brief later, but first, to kind of address one argument head on. I've heard some people recently in the right of center, more populist movement argue that the consumer welfare standard, which was created by Robert Bork, is the product of judicial activism and that it's judge-made law. And this really misunderstands both the law and the history of antitrust. So during the 1986 Supreme Court confirmation hearings for Judge Scalia, or then Judge Scalia, he was asked about antitrust. And I think he summed it up well, what the state of it was in 1986. He said, in law school, I never understood antitrust law. I later found out in reading the writings of those who now do understand it, that I should not have understood it because it did not make any sense then. So thanks to the consumer welfare standard and decades of judicial interpretations that have recognized it, including several notable opinions by Justice Scalia himself, antitrust makes a lot more sense now. So why is that the case? As Amy Coney Barrett said also during her Supreme Court confirmation hearing, you can tell, I guess, that I work on confirmations as well as deciding these hearings so often, but she said something that I think hit the nail on the head. She said, the text of the Sherman Act, as the court has determined over time, essentially permits the courts to develop a common law because it's largely been left to judicial development that is controlled by precedent for the most part. So let's do a little bit of a historical walkthrough here. So for decades, antitrust law was used with varying degrees of success as a proposed solution to dozens of different problems, many of which are completely unattached from the competitive process. For example, environmental concerns, income inequality, and a myriad of other policy objectives, mostly left-leaning policy objectives, I'll note. However, our legal system was built upon laws that have specific intended outcomes that solve a particular problem. The rule of law requires this very basic foundation. Otherwise, the law will be unpredictable, untenable, and eventually will serve too many masters. And that was the state of antitrust law really in the 1960s. So in the antitrust paradox, Robert Borg argued that Congress enacted the Sherman Act as a consumer welfare prescription. And in short, Section 1 of the Sherman Act prohibits activities that restrain trade if those restraints are unreasonably restrictive of competition in a relevant market. However, if you look at the actual language of Section 1 of the Sherman Act, it says every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce amongst the several states or with foreign nations is declared illegal. But really, under that plain reading of the text, most things are illegal. So shoes sold in pairs is one famous example of something that was illegal at the time. And then courts long ago realized that not every restraint of trade can be illegal because, as I said, a simple contract between two parties technically constrains trade on some level. So this realization first occurred right after the Act's passage and during the era of about 1890 to about 10 to 15 years later. And that's when the courts really struggled with the courts really struggled with how to interpret the Sherman Act. And this is something they really struggled with for the better portion of the 20th century. And antitrust law is really particularly rudderless in the mid 20th century and led to a lot of unpredictable outcomes. As Justice Potter Stewart said in his famous dissent, that the sole consistency he can find in antitrust laws is that the government always wins. And that sums things up pretty well as of the state of antitrust law, particularly in the 1960s. So eventually in the 1970s, courts came to interpret the Sherman Act to only apply to unreasonable restraints. And in 1979, only a year after the Antitrust Paradox was published, the court explicitly acknowledged the Sherman Act as a consumer welfare prescription. So what is the consumer welfare standard? So the consumer welfare standard uses economics to reliably predict when conduct is likely to harm consumers as a result of harm to competition. So it's broad enough to incorporate a wide variety of evidence and shifting economic circumstances, but it's also clear and objective enough to prevent being subjected to the beliefs of courts and the enforcers. In doing so, it honors the principles of the rule of law. So it's a broader set of principles, and it's not, consumer welfare standard is not statutory. It's a broader set of guidelines by which courts operate and by which we evaluate whether or not conduct is anti-competitive, and in those anti-competitive actions, does it harm the competitive process, which does harm the consumer. Another misconception I'll point out really quick about the consumer welfare standard that I hear a lot these days is that what do we do with digital markets now that if the consumer welfare standard is only concerned with price? And I'd like to clarify that's not actually true. The consumer welfare standard is also, and the courts have realized for decades that the consumer welfare standard is concerned with other issues such as innovation and product availability. And that was kind of at the core of the Microsoft case, actually. That was not based on price alone. So that's one misconception I wanted to briefly touch on. But today there are quite a few proposals in Congress that undermines what the consumer welfare standard and what it has stood for over the past few years. So to give an overview of what's been going on in Congress for the past year. So in October, the House Judiciary Committee ended a 16-year study in which it ended this 451-page report that recommended pretty much every change to the law that it could, recommended that Congress override pretty much every Supreme Court precedent that there is on antitrust from the past 40 years. It was a really broad set of recommendations. It was really kind of, throwing spaghetti at the wall to see what sticks. it would take me quite a while to sum up everything that was in there. So I'm going to focus a little bit more on some parts of that made it into recently the bill that was introduced by Senator Amy Klobuchar. Actually, 2 weeks ago, or no, last week or 2 weeks ago, I testified in front of the Senate Judiciary Committee on antitrust in a hearing that was about whether or not we should change our antitrust laws. And it was kind of meant to kick off the discussion over this bill. And what the bill does is it essentially protects competitors, which shifts the U.S. law into a bit of a different framework. So it's called the Competition and Antitrust Law Enforcement Reform Act of 2021, but that's a little bit of a misnomer, given that instead of just giving tools to strengthen enforcement, the bill is really a pretty radical overhaul of the way that our antitrust laws have worked for the past 45 years. It's also a warning to smaller companies not to become too large. So it essentially prohibits businesses from practice that would harm competitors. And the bill reinvents the legal standards that defines exclusionary conduct as conduct that materially disadvantages or tends to foreclose or limit the ability or incentive of one or more actual or potential competitors, rather than harm to competition in a relevant market. So that's pretty broad language there. So in the United States, our antitrust laws protect the competitive process rather than protecting the competitor itself. There's a reason that there are not many large tech companies in Europe, and it's not necessarily just because of antitrust, it's their regulatory system as a whole and a lot of other factors. There are a lot of studies on VC investments in Europe that are quite interesting, more pertaining to privacy law. But going back to antitrust, harming one's competitors is not an antitrust violation. Outcompeting competitors is how competition works, and profit-seeking motives alone do not establish antitrust liability. I'm quoting their great line from a Ninth Circuit opinion in FTC versus Qualcomm, in which is saying, antitrust behavior is legal and hyper-competitive behavior is not, and kind of sets aside the two differences. And kind of in that same vein, this bill, along with several other proposals that are out there, undermines IP protections. So although it explicitly excludes applying for enforcing a patent, trademark, or copyright alone from constituting exclusionary conduct, unless it's baseless or in bad faith, is what it says. However, these activities may be considered as part of a course of conduct that establishes exclusionary conduct. In other words, if you obtain IP protections to your property, it could be considered exclusionary conduct under Klobuchar's bill. Those two things, aren't really that much different. And this is really counterintuitive. In fact, I would say that patents are one of the greatest anti-monopoly devices ever created. It allows a single inventor, usually someone from far out of left field, someone you've never heard of, to disrupt an entire industry and tear down established companies with a property right in a new invention, or in a new innovation, sorry. But patents and other forms of intellectual property are frequently described as incentives to innovate, but this disruptive effect is often overlooked. Of course, this effect is only plausible with a strong system of intellectual property rights and treats patents and copyrights as property rights under the Constitution. So that's one point that I like to reiterate is one way to deal with the size of these companies and monopoly problems. We need to actually enforce our IP rights. And any legislative proposal should specify that applying for or enforcing a patent, trademark, or copyright is not exclusionary conduct. I think that's really a territory that we need to not venture into. Another thing this particular bill does, and several other proposals that I've seen out there do as well, is it shifts the law to this sort of risk-based framework. So rather than focusing on proposed mergers that present actual harms to consumers of the competitive process, it would add this risk-based standard to the foundational antitrust law. This bill in particular, it does so by amending the Clayton Act directly to prohibit exclusionary conduct that presents an appreciable risk of harming competition. So what appreciable risk is, that's not really quite clear. I've kind of called this appreciable risk framework is kind of like the I know it when I see it theory of competition law. And clearly that's not a tractable standard. And one of the last points that is found both in this bill and also throughout the House report and elsewhere is regarding mergers and acquisitions, and specifically that this legislation and others shifts the burden of proof to dominant firms, so proving mergers would not create an appreciable risk of materially lessening competition. So it puts a lot of discretion in the hands of enforcers and bureaucrats, and requires courts to rubber stamp these judgment calls that regulators are making. And it also doesn't really make much sense because, you know, shifting the burden of proof in the United States legal system, usually the burden of proof is with those who are making the accusation. And I think that's really core to our system of law. So, I mean, that kind of really goes against our basic system of fairness. And not only that, under current antitrust law, enforcers have adequate power to intervene. So the FTC and DOJ have only lost 4 cases in the past, I think, 8 years. And private litigants continue to bring monopolization claims all the time. So inverting the basic notion that the government bears the ultimate burden of proof to solve some, you know, crisis in litigation that doesn't really exist shouldn't really withstand scrutiny, particularly by conservatives, in my opinion. And shifting the evidentiary burden could also destroy incentive for government agencies to actively measure anti-competitive effects, while the defendant would need to clearly document pro-competitive benefits. So that's another issue with shifting the burden. This would not only be unfairly burdensome for the defendant, but it would make it impossible to win on an efficiencies defense, as is impossible to weigh pro-competitive benefits against something that's not identified. And you know, that burden shifting proposal is one of the proposals out there that I like to concentrate on a lot and draw attention to, because I think it's one of the worst proposals, and it does have a bit more bipartisan support than it should. And it also just doesn't solve any real or perceived problem. Like I said, there's no crisis in litigation. If there's an under-enforcement problem in competition law, this you know, could be solved by other means, such as giving more funding to departments so they can bring more cases. But there's no good reason to change the underlying legal standard. So that brings me back to my previous question about how our laws should solve particular problems. Some want antitrust, particularly on the left, to cure bigness, and they ask, you know, kind of how big is too big? And instead of asking, is it too big? I think the relevant questions are, 1, does it harm consumers or otherwise violate competition law in acquiring and maintaining a monopoly? As the Supreme Court held in 1911 in American Tobacco, that's, you know, the relevant inquiry there. And also, 2, just the basic what problem are we trying to solve? And that's very different, you know, depending on who you ask. It seems that there's this consensus gathering around, you know, reforming the law in some sort of way to solve 1,000 different problems, and none of them are problems that are actually competition. I'd also point out that over the past year, we've seen a lot of cases being brought, particularly against Google and Facebook, by the DOJ against Google and the FTC against Facebook, as well as the coalition, I think 48 attorneys generals led by New York against Facebook. And then with Google, there's the Texas suit and one in Colorado, and I believe one third one that I'm missing here. But it's that, you know, changing the legal standards after all these cases are being filed also sends a message to the federal judiciary that I do not think is a good one. It's essentially saying that, you know, they don't trust them to handle these cases correctly. And I think we, you know, litigation does move very slowly, and one could argue that, you know, maybe reforms need to be made so that litigation isn't as painfully slow as it is. I don't know how you would change that entire process, but still it would make a lot of sense to wait that out and, you know, see what happens, because I think that our courts will make the right decisions, and Congress should trust them to do so, because it really does undermine the judiciary to say otherwise. I'd like to end on a couple of notes about antitrust, populism, and the conservative movement. So alongside this conservative, like, populist antitrust movement of the past year or two, we've also seen the rise in this theory called common good originalism that has been the subject of much debate over the past few weeks. I know this is kind of an interesting link of the two that I'm making, but I see a lot of parallels. The common good originalism, the doctrine, I would say it's not common, it's not originalism. Essentially, this doctrine is an attempt to disguise judicial activism, in this case, legal interpretations that lead to desirable policy outcomes, a lot of which are just anger over Bostock, as some sort of new originalism, and that doesn't quite work. But interestingly, those who follow the doctrine of common good originalism also tend to believe in antitrust. activism. In fact, if you were to make a Venn diagram of the conservatives who believe in both, it would just be a circle, pretty much. And that's not really, you know, that's an outside of the mainstream sort of view. And it's also because the reason for the overlap, I would say, is because these activists hate largely objective standards, such as the consumer welfare standard and textualism and originalism, because it restricts to their power to remake the society for the common good, as defined by, you know, the movement's intellectual fashions, which is something, you know, we've seen on the left for decades. And perhaps Woodrow Wilson said it best when he states that we can't let a cramped interpretation of the Constitution limit all the good we want it to do. So these activists would like to apply the same idea of 2 decades of courts interpreting the Sherman Act as a consumer welfare prescription. And both movements are premised on the idea, really, that the law should be malleable and meet preferred policy outcomes. And that not the consumer welfare standard is a type of activism that I think runs contrary to the rule of law and will have really some devastating outcomes in the end if we give up, you know, something that has you know, prevented and been a safeguard against judicial activism by giving judges a set of principles. So really, the consumer welfare standard in the current state of antitrust law is exactly the opposite of that. It's prevented judges and enforcers from, you know, putting their activist goals and their different policy prescriptions into antitrust. So I'll stop there, seeing this about 3:35 or so, and take any questions that you may have.
So if anyone has a question, you just raise your hand and then I'll ask to unmute you. Okay, Kyle.
Yeah, thank you so much, Ms. Baker, for coming. You touched on this a bit, but something I've noticed is like a political trend, especially like with big tech, is that those on the right are becoming increasingly more skeptical of corporate wealth, while those on the left are becoming more supportive of big business. Is this a trend that is manifested at all in antitrust law and the Supreme Court?
It has not manifested itself in the Supreme Court. I mean, the legal interpretations of really, their courts have not differed in recent years than they have in years past. And I would say the left is more skeptical of corporate power too. And I would also add that it's not at all wrong for the right to be skeptical of corporations. And I think there are plenty of very valid reasons to not like the actions of these corporations. The left and the right have very different reasons for not liking them. But I mean, I do think that these concerns over speech and over privacy, for example, those are very valid concerns, but they're not competition concerns. And, you know, to address part of your question about corporate wealth, I mean, if you look at, it's not as if CEOs are getting richer and everyone else is getting poorer. You still see a general dynamic of prosperity. You know, we as conservatives have never been in favor of the redistribution of wealth. You know, the left does that, and they originally would do that more through our, you know, rewriting our tax codes. And now when they've, you know, their failures to do that has resulted in them trying to, you know, use antitrust instead of tax codes. And I think, you know, if you're going to do that, if you're going to redistribute wealth, you know, antitrust is not the legitimate way to do it.
Thank you.
If that answers your question. Sorry, I know this is such a broad topic to cover in any short period of time, so I try to do my best.
No, yeah, that does. Thank you.
I have a pretty broad question as well. Using the consumer welfare standard, do you have any idea of like what the outcome will be for these pending DOJ cases against Google and Facebook and stuff?
Yeah, so I don't like to comment on any pending litigation, and part of that is because some of the facts are still surfacing. There are documents that I'm not, you know, and I'm also, you know, not an attorney for Google or for the government, so I don't really find it appropriate to comment on outcomes. One point that I do like to make about the case against Facebook, however, there are some broader issues with that case, I think, in terms of the FTC's enforcement authority. The FTC can, you know, do, so they, by unwinding that merger, that'd be kind of a shift to like ex post merger enforcement, which is legal technically. However, there's good reason why that shouldn't be done. And it's because smaller companies, you know, M&A has been viewed as an exit strategy for a long time, and that's a viable exit strategy for a lot of these companies. And when you take away that possibility, and the FTC suddenly says, okay, well, we can unwind mergers later down the road if the company becomes too big, that really affects venture capital investment a lot, because that gives them less incentive to invest in those companies. Instagram at the time was not seen as necessarily being a competitor. It also kind of deals with this hypothetical world in which, Instagram on its own would have grown to compete with Facebook. We really don't know if that's the case. So that's what I'll say about the FTC and Facebook case. The cases against Google, the Texas case is pretty complex, and actually a complaint was amended, I believe, like 2 days ago, and I've yet to kind of catch up on that, but that's more regarding the ad industries. It accuses them of a lot of things, way too much to cover here. The DOJ case is interesting in that it somewhat mirrors the Microsoft case. I'd say the primary difference between this and the Microsoft case is that, in the Microsoft bundling of the browser, you didn't have the option to switch like you do in this case against Google. I think it's really significant that the consumer can, change their default browser if they would like to.
Thank you. And then, so do you think the consumer welfare standard is still a strong check on like 21st century corporations and like big tech? I know you're saying, sorry.
I'm sorry, go ahead.
I know you're saying that was used for the big Microsoft case in the 90s, but I feel like just these corporations have gotten a lot bigger, a lot more powerful since the 90s.
Yeah, but I mean, look at the Microsoft case, and what eventually caused Microsoft's decline wasn't even antitrust. It was really just that they failed to integrate and move into the mobile market. It's competition comes in ways other than just creating an exact replica of companies. But I do think that it's up to the task. There are certain tweaks that I would endorse, not to the consumer welfare standard itself, obviously, but to antitrust law as a whole, such as there are a lot of exemptions in antitrust law for example, nonprofit hospitals. Then CAA is essentially exempt, and there's a Supreme Court case that will be decided this term about that. I do think it needs to apply to everyone equally. But I do think it's up to the task. I think that antitrust is one tool, like in a broader toolbox to use against tech companies. And I do think, for example, that we need to pass a federal privacy bill, a data privacy bill. And that's one thing that would be helpful. There are different views. I'm no expert on Section 230, so I'm not going to get into that. But there are speech-related concerns and solutions too that can be resolved that are a lot more appropriate for speech-related issues. So I'm not saying that they're not doing anything that I dislike, because that's certainly not the case. But in terms of competition policy, I think the law as is serves us pretty well.
Thank you. Does anyone else have any questions?
I think there's some stuff in the chat. Oh, okay. I answered that question. Excellent.
On privacy, do you have an idea of what a privacy law would look like, briefly?
Yeah, that's a good question. And it's, there were a lot of proposals out there for privacy law about 2 years ago, and it seemed like that there was a lot of hangups over that. And what I wouldn't want to replicate GDPR, for example, that has such a high compliance cost, and also speaking of bigger companies, the larger companies are already having to enforce it. So it actually works as entrenchment when the smaller, and there's a reason why the larger companies now are arguing for something that's like GDPR, such as having like a chief data protection officer. That's a really expensive part of the process. I also what I wouldn't want is a private right of action. And privacy law, we see how that worked out in Illinois for their biometric law. And I think biometrics and data protection in the sense such as CPA or GDPR, those are two very different issues and should perhaps be legislated separately. But some sort of, I don't know if maybe some sort of like voluntary consensus framework would be the solution. I know the uniform, I said in my bio, I'm working on a drafting committee with the Uniform Law Commission over a state uniform bill, and I'm not sure what that will look like yet, but that is one interesting alternative, I think, to something coming through Congress, which might take quite a bit. Maybe it'll also come industry by industry. It's been quite a while since we've had much of an update to HIPAA, for example. So that's another way that we can see it, change incrementally made.
What about leaving it to the states? Is that ridiculous these days?
I mean, so that's the problem is with that. I mean, I'm a big proponent of federalism, and hypothetically, I would like that sort of solution, but due to just the nature of the internet being, across state lines, it makes it pretty impossible with an issue like privacy. And for companies to comply, because companies then have to comply with all of, if they have users all across the United States, they have to comply with, the law in California and law in other places too. So like now what we're seeing is, because there are state laws being passed, this kind of like patchwork of like inconsistent or at times contradictory regulation. So I think that makes it make a lot more sense for it something to come from the federal level for consistency.
Thank you.
Yeah, Nevada actually does have a privacy law, so does California, and Nevada's is just way weaker than California's. It's crazy, actually.
Yeah, California is a lot. It's definitely modeled after GDPR, and there's a ballot initiative that strengthened it a bit too. I think it helps the larger companies and kind of hurts the little guys in compliance. But at the same time, we do need those protections on personal data.
Any other questions? Okay, Nicholas.
Hey, how you doing? Thank you for coming today. I was wondering if you had any take on the New York proposed law. I guess it's an abuse of dominance standard, and what you thought about abuse of dominance as a thing worth having or not worth having.
So I'm not that familiar with the exact language of the New York law. It's kind of hard to keep track of all these proposals on the state and federal level too, and the suits. Abuse of dominance, though, I mean, it's not exactly the same as the standard I was talking about earlier, the appreciable risk and the harm to competitors, but it's very, very similar, and that it really is rooted more in kind of what the EU uses. And I mean, abusive, it's such a big term. I mean, it could be applied to so many things. So I think that really just throws out the consumer welfare standards. That we need to it makes sense that judicial decisions are based on a theory of harm. And that really throws out that theory of harm and is just about, an action that's, maybe just hyper competitive, but doesn't hurt anyone but their competitor, because, hurting competitors, so to speak, is kind of how competition works. So I think it would leave open some really incredibly broad interpretations. It would, make room for, those other policy incentives for lawyers to do some creative lawyering, so to speak, in courts.
Thank you.
Anyone else? I think that's it. Thank you so much, Ms. Baker. That was really interesting.
Thanks. Well, feel free to follow up with any questions, and I hope you enjoyed that. Like I said, it's hard to. I think Professor Trimble has her hand raised. Oh no, you don't. Okay.
Very much for your talk. We appreciate you joining us today. Thank you.
Thank you. And thank you for all coming out. This was fun.
Thank you.
Right.
And then I'll send you the recording as well, okay?
Okay.
Thank you.
Thanks. Have a good day.